Morning, morning, morning. Good morning. Good morning to you.
We're looking at unraveling unfair dismissal, the impact of an incorrect procedure. And that's something that can snowball in a way that, boy, we know all about. So, to join us in this morning's discussion, we have to welcome the president with the most, Human Resources Management Association of Barbados head, Nicholas Roberts, is back on this Wednesday, and he's brought along a familiar face, Michelle Russell, attorney at law, employment law, and industrial relations. Good morning and welcome.
Hi, good morning.
Hi, good morning.
All right, first of all, this morning, Nicholas, Michelle eclipses you only because we've not engaged in this way in quite some time. So it's wonderful to see you as always, Michelle.
Yes, always a pleasure to be here, Tisha.
All right, good stuff. Nicholas, let's set the tone. Since we've had changes to the laws as relates to employment rights, there has been a lot happening with the employees and employers, and sometimes it can get a little contentious. So I'm going to invite you to start by setting the tone for us about the options that are available to resolve any disciplinary matter or dismissal issue that there is.
So thanks for that, Tisha. So in terms of setting the tone, what I will say is that HR practitioners, and not only HR practitioners, organizations, labor, lawyers like Michelle, usually advocate for it not going in a contentious way. So generally, if there is a grievance within the workplace, we as in the HR department would ask the employee and the employer and their direct superior, or if it's two employees on the same level, to have a conversation. And that informal conversation is aimed at trying to see if it is that they could come to an amicable situation without it getting contentious. And this is called alternative dispute resolution. The aim for this is to have conciliation or collaboration problem solving. In the event that the two employees cannot resolve the matter, whether they're on the same level, whether it's a superior and a subordinate, then HR can come into the midst and act as a third party, to act as a mediator to try and see if it is that they can bring the solution, the issue or the problem to some amicable solution. Once again, we're trying to get this issue resolved within the organization without going the formal route. No, sometimes, unfortunately, within organizations, there are instances where grievances have occurred that they are so egregious that they cannot be resolved through informal matters, and a formal grievance procedure has to be enacted by the organization. And this is usually done by done within the organization by the HR department on behalf of the organization. And unfortunately, this is where things usually go a kilter in terms of things being done wrong. And attorneys like Michelle would say, for instance, if it is that the procedure is incorrect or improper, you automatically have an unfair dismissal occurring. And that is what we've been seeing happening a lot over the last 2 years through the enactment of the Employment Rights Act and through HR departments and organizations trying to follow the letter of the law, but not getting it done to the best of their ability in some instances.
Yeah, I find sometimes we forget about the human in human resources, and that's very, very important when we're dealing with people in order to move away from just really sticking to the letter of the law. If we're being honest, Nicholas. Michelle, I think I might be a little controversial now with my next question. Nicholas talked about human resources acting as a mediator in a situation where there might be, a conflict, where people are on the same level, or a superior supervisor subordinate type situation. Do you think people believe that they're truly getting the representation they deserve in HR offices across Barbados when they have HR coming in to act on behalf of what many people think is the company?
Well, I will say this, and it reminds me of something I mentioned earlier in the year. People often forget that HR is an employee as well. So whether you're the HR manager, the HR officer, you're an employee as well. But you're employed to somehow be this bridge between management and the employees. But you are also subject to all the disciplinary rules, instructions, etc. from your superior, aka management. So it's this weird thing of trying to balance the instructions you get from senior management. And more often, particularly if you're an HR manager, you are part of senior management, so that you have to carry out their mandate while also trying to take into account the interests and the human element of the employees. But sometimes the two clash, and you are stuck in the middle where you need to follow the instructions of management, because like I say, you're an employee too. So if you don't follow the instructions, you can be held liable for or be subject to disciplinary action for insubordination. But you might already also be trying to take into account the best interest of the employee, and you essentially end up having to choose one, and as an employee, you're going to choose the one that essentially tells you to obey what management says. And so this is why you find that oftentimes HR seems to become the enemy of employees, or employees don't trust HR. It's not always because HR is unreasonable or HR lacks empathy and compassion. If sometimes HR is stuck because, like everyone else, they're employees and they can only do what management say they're to do. But at the management level, you expect that they would advocate on behalf of the employees to put the human element or the employee position, in the hope that management can be swayed somehow. So there are instances where, because of the mandate, HR isn't necessarily a safe space for employees. And I think that's why some companies hire employee relations managers, because they're supposed to be the better go-between, where they primarily represent the interests of employees, whereas HR tends to more represent the interests of managers. But Nicholas can correct me on that one.
Yeah, Nicholas, I definitely want you to weigh in on that.
Yeah, I think Michelle, and you did say it's quite controversial, but you're correct. There's no way of shying away from it. I sat on a panel last night for Rotaract, and one of the audience members said, "What can I do if there's a grievance procedure within your organization, or I have a grievance and I can't go to HR?" I said, "So why can't you go to HR?" They said, "Because HR doesn't like me." And Michelle raised a very valid point, and I did raise that last night. At the end of the day, I think people forget that HR practitioners are your HR department, are your employees as well. So we are stuck in a very precarious situation where we are representing the needs or the wants of the business or senior management, as well as trying to advocate for employees. And Michelle is correct. We are ourselves employees. So there's that gentle balance and that fine line that always has to be traversed in terms of how we handle situations when it is that we are looking to see that we can resolve things in the best way for all parties. And unfortunately, because a lot of managers within organizations do not like to perform their HR function, because they say that all of the time. HR is a function. And if you are a people leader, if you're a supervisor and you oversee people, you have an HR function. But people or managers within organizations do not see that. They always push it down to the HR department or to the HR manager or HR officer or whoever. And then that is how HR becomes the enemy of employees, because it is seen as HR is the one that is always bringing down the hammer. And HR practitioners are not hatchet people. We're not there to do the dirty work of the organization. But unfortunately, that comes with the job. However, if it is that we need to do it, I always say that we should be doing it in the most humane way, as you preface the conversation, as possible, because we are here to do a job. And I think that if it is that we have to reprimand employees, it's always trying to reprimand employees in a way that we leave them with dignity, whilst getting the needs of the organization or the wants of senior management executed.
Absolutely. That's why you're Mr. President. Well said, Nicholas. Well said. So let's delve into some of these disciplinary processes in the workplace and talk about how they can lead to unfair dismissal, Michelle.
I'm going to talk about that, but I wanted to just jump onto something Nicholas just said. When he said HR managers should carry out the mandate, so that the employees still have some dignity. And I want to address something I don't often see spoken about, which is the issue of burnout. There are certain professions that you're going to burn out more quickly, especially if you are in a profession that deals with a lot of contention. So that day in, day out, all you're dealing with is complaints, contention, conflict. You will burn out much quicker. So that what I have found is that a burnt out HR officer finds it way harder to show empathy. The same as in my role as a labor attorney, when I am coming to my wits end from too many disciplinary hearings, too many tribute, too many anything, I literally have to stop and take on nothing else that's contentious, because I find I get irritable. I am less empathetic. I am less compassionate. I'm short-tempered. My words are catty. And I find that what we have to do with HR officers is be able to make sure they take their vacation, or they won't be able to exercise the human element necessary, that delicate balance. Moving on to the question you've asked.
All right.
The
So in other words, do what's in place by the organization as a function of what you're supposed to do. Take your vacation, which is what you advocate for us to do. Yes. All right.
But
So
HR
on now to
often don't. They
yeah.
don't. They put off vacation way too often.
All right, Nicholas, take heed. All right. So on to this disciplinary process in the workplace that can lead to unfair dismissal.
Okay, so normally, and this is important, as long as an employer is contemplating any kind of discipline against an employee, they must activate the fourth schedule of the Employment Rights Act, which I'll just refer to as the ERA. Now, people somehow still mistakenly believe you only activate the disciplinary procedure for dismissal, so that they believe that if you're contemplating dismissal, then you have to go to the fourth schedule of the ERA. But that's not true. When you read the fourth schedule, it says if an employer is contemplating disciplinary action, then they must essentially activate what is the disciplinary procedure, which is you invite the employee in writing to a meeting. And in that letter, you have to set out in detail the allegations against the employee. Now, while the act is essentially prescriptive, so it tells you what needs to be done, it doesn't necessarily go into detail. So this is where the case law becomes important. This is where having labor attorneys assist you is important, because the case law essentially says that in setting out the charges, the employee must know the case he has to answer. So you cannot say something vague like for being loud in the office, because then the employee is like, when was I loud? Who was I loud with? Who heard? Who complained? What is the level of loudness that's allowed? Is there a decibel level? The employee must not have to guess. So you must set out the charges with detail and specificity, and provide copies of any documents on which you're relying to support the charges. You set a date for the meeting. The letter must tell the employee he has the right to bring a representative of his choice, and the employee must get adequate notice of the meeting. And this has been a sore point for me over and over, where employers like to do this thing where on Monday they give you a letter inviting you to a disciplinary meeting that says bring a representative and this is the charge, and the meeting is Wednesday. Or the meeting is Thursday, and they like to hide behind the section in the fourth schedule that says the meeting should, as much as is possible, occur within 7 days. But within 7 days doesn't mandate 7 days, because if we go back to the case law and the spirit of the act, which is the employee must be given a reasonable opportunity to consider his response, which I think it would be clause 2 of the same fourth schedule, literally says the employee must be given a reasonable opportunity to consider his response. Can an employee who gets a letter on Monday evening be ready for Wednesday? At what point do they get to consult with a representative? The representative might already have pre-scheduled meetings, events, etc. So that you must be reasonable and give at least 7 days. And this is why I like the case of, I believe it was Pauline Wood and Jada Builders Inc., where Deputy Chairman Kathy Ann Hamblin actually spoke to it, where they gave the employee only 48 hours notice of the meeting. And she chastised the company for it and said this is not possible that an employee would have a reasonable opportunity to consider their response. And so that employers must do that when they invite you to the hearing.
All right. Lots and lots of areas that we still need to cover. But Nicholas, I know that you are having a session this afternoon. I don't know if we're invited as non-human
You're always
resources
invited.
practitioners, but tell us more about that as we wind up today's presentation.
Yes, definitely. So you're always invited. So that is going to be led by former chair of the Employment Rights Tribunal, Justice Blackman, who will be analyzing the case of the National Union of Public Workers versus Rosalind Smith. And as you can see, Michelle Russell as well as Michael Koyman, who are two prominent attorneys, will be sitting on the panel, and they will also be providing their analysis. And the reason for this case is because, as this morning's discussion, a lot of cases that are seen by the ERT, short for the Employment Rights Tribunal, just for reference, the majority of them have been won by the employee. And this is because, once again, organizations and HR departments, by extension, get the procedure wrong somewhere along the line. So because Justice Blackman has overseen this case, we've asked him to come, and he has so graciously accepted our invitation. And like I said, Michelle and Michael will be there to provide their analysis on the case as well.
Where, how do we get involved?
Yeah, so it's going to be at Tapas this afternoon. And registration is closed, unfortunately, but what I can do is that I can come back and give an update next week or
Absolutely.
so. It will be at Tapas in Hastings. The turnout for it has been, we started this back in 2019, so this is going to be the second one in the series of things. Obviously, COVID put a damper on it, and back then we had the first one. We did an analysis of the first citizens case, and like I said, we're reviewing AUPW versus Rosalind Smith, and it will be at Tapas this afternoon at 12:30 p.m.
Oh, that's amazing. I'm excited already, and I'm not even there. You know, we have to work together because these are things that people should see. They should be more memorialized so people, even if for posterity, for people to be able to reference it. I want to thank you so much. Great to see you, Michelle Russell, attorney at law. She used to be my go-to resident person in another life on another
Yes.
show. And good to have you, as always, the president with the most, Nicholas Roberts. Have a great day, guys.
Thank you.
All right, so definitely lots to think about. What's most important, though, I think the takeaway from this is that you should know the Employment Rights Act. Make it your business to read it.
Morning, morning, morning. Good morning.